That's good. Okay, now I'm going to do the share screen function here so we could begin. Which one was it? Okay. Okay, do you have that on your screen? So let's see.
Yeah, I can see
Yep.
it.
Okay, good. So that's the principle. Okay. Oh, I actually thought I was going to
G'day,
say.
everyone.
So good evening, everyone. So there are three things we are going to try to do today. We will try to discuss the IRAC format in answering case problems. And then we will discuss the role of the upper house and obviously the lower house in Australia's parliamentary democracy. And then examine some key issues of the representative principle in Australian constitutionalism. In going through the last two learning outcomes, we will be delving on the discussion questions. Now, before I continue, the question I'd like to ask is, would you be interested in us trying to go through the IRAC format? I raised that question because I understand many of you actually are first-year students, and you might be unfamiliar with doing the IRAC format. The IRAC format is important in the way you answer the legal problems or repost and the legal memorandum. So what do you think? Should we discuss a bit the IRAC format? And in doing so, I could probably actually use as an example one or two of the problem questions of the legal memorandum. I'm not going to be providing the answers. All I'm going to be doing is to give you an idea or some guidance on how you should be addressing the problem questions that are in the legal memorandum. Now, I can't seem to see everybody there. Hold on. So what do you think? Do you think that we should try to go through the IRAC format, or do we go straight into discussing the topics in week 3? So who says, yes, we should have the IRAC format? Unfortunately, I can't. I'm going to get off the share screen for now because I can't see everybody. Hold on. Okay. So the question is, would you like us to briefly discuss the IRAC format? If we have to go beyond the time, like beyond 1 hour, I'd be willing to do that on the assumption that there is no other class that will be using the same license for Zoom. So would you like to go through the IRAC format, or should we start discussing the week 3 topic? Who says you'd like to go through the IRAC format? Can you raise your hand? Because that's all I can see for now. I don't see too many. The others have cut off their videos. I have no way of knowing. Okay, the others say week 3 first. So how do we do this? Do we go through the IRAC format, or do we go through the week 3 topic first? Okay, so okay, let me just quickly go through the chat here. Hold on. Week 3, please, for the others. Yes. Okay. So what we're going to do is we'll discuss week 3 first, and then we'll try to find time for the IRAC format, because there are, it seems to be, the house seems to be quite divided. So let's just go through the topic first of week 3. And then perhaps in going through the week 3 topic, we can also just apply the IRAC format anyway. And we'll see how it goes. So are you happy with that? Any objections so far? Perhaps none? Now, obviously, let me just say let me begin by saying hello, and I apologize for the slight delay. I had problems. It could have been worse had I been using Blackboard Collaborate, but Zoom was a bit better. Oh, now Zoom just is beginning to quit on me. Hold on. Okay, I'm still there. So let's do the share screen again. Okay. So again, let me repeat. What we're going to do for now is to spend time discussing the week 3 topic. And after that, we could separately discuss the IRAC format. I'm going to have to mute everybody else. I don't know how to do that now. Hold on. There's meant to be a function here because... okay. Can I just ask everyone else to turn off your microphones? Because I'm getting a lot of noise from the others. So can you just mute yourselves in the meantime? Turn on your microphones when you want to say something. But in the meantime, I'd like to ask you to mute your mics because we are picking up a lot of noise. Okay, so we'll go through the week 3 topic, and if need be, we'll try to apply the IREC format where that is applicable. Okay, so happened there. Okay, there. So that's the discussion question 1. Under the principle of responsible government, I'm having problems with my screen. Hold on. Okay, let's just do it that way. So under the principle of responsible government, the Governor General acts on the advice of the Prime Minister. By what legal authority would the Governor General have to dismiss a Prime Minister who refuses to tender the resignation of his ministry? Okay, now what I'd like you to do is, you've probably had the chance to think about this question, so I'm just going to give you about 20 seconds to think about this. And then I would like everyone to try to answer this question through the chat box. So I'd like everyone who is part of this Zoom session to give your answers in the chat box. I'm going to go through all those answers later on. I may not be in a position to actually read everything, but I'm doing this in order for you to be more actively involved in the Zoom tutorials. Because remember, you're not just here to listen to me. I'm hoping for there to be more engagement from you. And one way of forcing you to engage with the subject and with me will be to answer these questions, at least through the chat box. Now, if you want to raise your hand later on and actually be able to answer orally, feel free to do so in a short while. But in the meantime, can I just ask you to start writing in the chat box now what you think is the answer to discussion question 1? Because this was the topic for last week, I would imagine that you would have had sufficient time to think about this and should be in a position to actually answer it. Okay, so please answer that discussion question and put your answers in the chat box, and then we will proceed from there. Now, because I can't see the chat box, I'm going to get out of the share screen for now. Oh, I'm having problems with my computer. It's hanging. Hold on. Nope. Okay, I'm not in a position again to see the chat box. Now, the only way for me to deal with this would be to get out of the Zoom, but I don't want to do that. So just put your chats there, and we'll see how this goes. So has everyone had the chance to actually put in their answers? Okay, are we ready? Okay, so would anyone wish to answer that question? And, you can use your mic for that. Any volunteers?
Yeah, I'll have a go, Manjo.
Who would that be? That's Paul?
No, Tony.
Tony. Okay, yeah, Tony, go ahead.
Yeah, I had a look at the dismissal letter that John Kerr gave to Gough Whitlam in 1975, and it says the authority is under Section 64 of the Constitution.
Mm-hmm. Yes.
Would that be right?
That's right, because Actually, under 64 of the Constitution, it provides that the ministers of state who are appointed by the Governor General actually serve at his pleasure. So on the basis of Section 64, under the clear provisions of the Constitution, the Governor General can dismiss a Prime Minister who refuses to tender the resignation of his ministry. But the second answer to that is that it is part of convention, a long-standing constitutional practice, that even in the absence of this Constitution, because remember, the reason why I speak of convention is that in the UK, there is no constitution. They don't have a written constitution. And yet, it is the Queen has the power to actually dismiss a prime minister. So therefore, in the context of the UK or in other parliamentary democracies where there is no constitution, such as New Zealand, you cannot argue or say that the power of the Governor General to dismiss a prime minister rests on the Constitution, because they don't have constitutions. There is no constitution in the UK. There is no written constitution in New Zealand as well. So in that case, where would the power rest? It can't be the Constitution. So in the case of Australia, it would have to be two reasons. One is the clear provision of Section 64 of the Constitution, which provides that the Governor General actually has the power that the people that the Governor General appoints to as ministers of state of the Commonwealth serve at his pleasure. But secondly, as a matter of constitutional convention, the Governor General has the power to dismiss the Prime Minister in certain cases. Okay, so the answer was correct. We just want to add that other aspect that by convention, it is recognized that the Governor General can dismiss a Prime Minister who refuses to tender the resignation of his ministry. Any questions so far?
Yeah, I got another question on that.
Yes, go ahead, please.
Is that a legal authority? Is a convention classed as a legal authority?
It absolutely is. Yes, it is.
Yeah, okay, thanks.
It is. So when we speak of a constitutional, of a convention or a long-standing constitutional practice, it is recognized as part of the law of the land. Okay, it may not be in the Constitution, it may not be in written form like statutory form, but it is recognized as part of practices and will in fact be enforced by the courts. And that is an example of a constitutional convention. The power of the Governor General to dismiss a Prime Minister. Do we have any other questions so far? So that's clear? Okay, so we can proceed. Now, in Cormac versus Coe, because this is quite short and brief, I'm just gonna read it for you. Justice Menzies said, the Honorable Justice Menzies said that the courts will not interfere with the proceedings of Parliament or the Houses of Parliament. Now, why are courts disinclined to interfere with the proceedings of Parliament? Again, as I said, I cannot see your chat box and I've got a problem with Zoom. The only way for me to see the chat box is to kind of force quit the Zoom software, but it will have to mean I'll leave this meeting, and I don't want to do that. So again, can I just ask you for the next 30 seconds to try to type in your answer in the chat box of Zoom. I will later have access to the chat box. In fact, anything that you type in the chat box, I will later upload that in our Moodle site so that students can both see a video recording of this session, and at the same time, they are in a position to actually see your answers. And because you have engaged in tonight's session, not just being present, but actually engaged by answering the questions, this counts for the group participation. Okay, so can I ask everyone to type in his or her answer to that question there? Why are courts disinclined to interfere with the proceedings of Parliament, according to the case of Cormac versus Coe? Okay, we're done. Okay, so again, would anyone care to answer that question? I wish I could say the chat box, but all I see in my Mac is that revolving ball, which tells me it has hung, and I don't want to get out of the Zoom session, as I said. So could I have a volunteer? Would anyone care to answer question number 2?
I'll have a go.
Who might that be?
Molly.
Molly. Okay, go ahead, please, Molly.
They won't interfere because of the separation of powers doctrine.
Okay. What does that mean?
Because the three powers of government are separated. They're separated, so one branch of government can't have more power than another, so the lawmaking is fair, and so people can have confidence in their government making fair decisions.
Okay. Now, if we follow that argument, we know for a fact that the High Court has the power to invalidate laws of Parliament if they are unconstitutional. Wouldn't that be interfering with the powers of Parliament?
I suppose.
So if it is, how can we say, therefore, that the reason why they won't interfere with the proceedings is because of its respect for a co-equal branch of government? I mean, if the High Court has the power, at least the Australian High Court, if the Australian High Court has the power to invalidate a law, obviously that's a clear sign of an interference with the powers of Parliament. So how can then we say that that is the reason why they wouldn't interfere with the proceedings of Parliament? Thank you for the answer, Molly. I mean, that was a good, that's a good preliminary answer. All I'm doing now is to try to dig deeper into the subject, because oftentimes,
Manjo?
Yes, who might that be?
Sorry, it's Jamie. Sorry.
Yeah, Jamie, I apologize. I don't know, I can't see who's wanting to speak. There are only 4 people I see now, but the rest I can't see. I've got a problem with my screen. So
well, that's
Jamie,
okay.
Go ahead, please.
I was just going to say, would it have anything to do with the fact that judges on the High Court are appointed by the Governor-General, whereas Parliament and the ministers that represent Parliament are elected by the people, which then represents their best interests? So when the High Court judges want to make decisions which may interfere with the Parliament, it doesn't really represent what the best interests of the people are because they're appointed.
Okay. So how do we answer the question there? What's the answer to the question?
Well, I was just saying that's probably why they're reluctant to interfere, because it's not really what the people want.
Okay, just for me to clarify that answer, are you saying that the High Court, before it can actually adjudicate, especially in relation to the activities of Parliament, they would wish to know the wishes of the people? Is that what we're saying?
Well, it just their decisions to adjudicate wouldn't reflect the best interests of the people because they're appointed by the government. They're not elected by the people.
Are you saying, therefore, that the High Court judges acknowledge that they don't actually have the power to interfere because they are not elected?
Yeah, correct. So they would hand it back to the Parliament because the Parliament is elected by the people, and they would have confidence that the decisions the Parliament makes are in the best interest of the people who elected them.
But if you look at the Constitution, the power of judicial review actually lies with the judiciary. It is. So meaning the Constitution itself grants the High Court the power of judicial review. So it doesn't need a mandate. I mean, there is already the mandate for the people in the fact that the Australian Constitution, which is the fundamental law of the land and is representative of what the people want, actually authorized the High Court to look into certain actions of Parliament And at least in the case of laws, it can be invalidated by the High Court.
Can I say something, Manjo?
Yes, please identify yourself.
It's Michael Dunn.
Yes, Michael.
Is it the case in that, was it the case in that matter that the High Court wouldn't become involved in the law-making process, but they were happy to become involved once the law had been passed to critique it, I guess, in the as per the Constitution?
Yes, that would be correct. So,
hey, sorry, Manjo, Peter Ritchie here.
Peter Ritchie,
with regards to that, it would be right to say that the courts would only have the right to consider the constitutionality of a law only if it's been brought to their attention by somebody with standing or the Governor General. If it's not brought to their attention by somebody with standing, it can essentially stay there as an unconstitutional law until such time as it is. Would that be right?
You're very correct. Yes, yes. But in relation to this case of Cormac versus Cope, there were actually two senators of the Commonwealth who initiated proceedings in the High Court questioning the dissolution of both houses and then the subsequent attempt to pass 6 bills. So there was that question. There was actually an attempt to enjoin or restrain the 2 houses of Parliament that had been called and convened by the Governor General. But there was an attempt by these 2 senators to prevent the 2 houses of Parliament from convening. So, and it was clear that because they were senators, they actually had the legal standing to bring the proceedings. But you're correct, Peter. In general, you can have a law that is unconstitutional, and unless there is somebody with an actual standing, in other words, somebody whose rights are affected or upon whom a liability is imposed by a law, meaning the locus standi, it's possible that the law will continue to operate and be considered valid because there is no judgment from a high court or a federal court or any court for that matter that has declared a specific law to be unconstitutional. Now, let's just dig deeper into this aspect. So the High Court pointed out that the best time for the High Court to intervene, or that according to the Constitution, the time when the High Court intervenes is when the validity of a law has actually been questioned before it. In this case, there was no law that was actually sought to be questioned. It was just 6 bills, including something that had to do with the petroleum bill. So there was the question that the only time that there could be a dissolution of both houses is when there is a bill that was passed, but at that point there were actually 6 bills involved and so on. So the High Court was saying that the power of the High Court to use its power of judicial review can only be triggered when there is actually a law that has been passed, and then there is a proper question as to the validity or constitutionality of that law, but it couldn't be in relation to bills. So that's one. So that's a technical issue there. And obviously, the power of the High Court here, when it was sought to be used, it was actually on the basis of the provision of the Constitution that the High Court has the power to prohibit or enjoin the activities of any officer of the Commonwealth. And in that regard, the High Court was saying that it was not in a position to actually enjoin a proceeding of the Parliament because, it wouldn't interfere with its proceedings until such time as a law has actually been passed. Okay, so do we have any questions there?
Yeah, it's just Patrick Fitzgerald. I've got a question in relation to this. So the Parliament is elected by the electorate, and so in turn the executive is elected by the legislative. So the judiciary stands as a body within the Constitution that has no policy agenda as opposed to the legislature, which does. They just stand there as a means of review of the validity of the laws that they implement. Is that correct?
In general, that is correct. Yes. It is clear that on the basis of the representative principle of a democracy or of constitutionalism, national agenda and national policies are set solely by the elected representatives of the people, which means it's either the executive or parliament. However, it's not as simple as that, because even in the case of Cormac versus Co, the High Court was saying that sometimes decisions are made according to what goes on at a moment in the history of the nation. So in other words, the High Court or the judges actually take cognizance of what is going on. So for that reason, because of the cognizance of changing circumstances, it's actually possible for the High Court to infuse a level of agenda into its policy making, into its decisions. It's not meant to, but in truth, if you speak of what is known as an activist court, judges, in fact, do make law, and they often do. And that is especially crucial, or that is actually especially important in the case of common law systems, where judges are said to make the law. In other words, in the absence of a specific statute, assuming that there is an actual controversy and the power of judicial review has been invoked, and it is not in the statute books, there's nothing in statutory form that would provide judges guidelines on how to adjudicate an actual controversy. In common law systems, judges are not prevented or are not debarred or prohibited from adjudicating or determining or coming up with a decision on that actual controversy. And therefore, in doing so, because they are in a position to adjudicate even in the absence of specific legislation, judges do in fact use some kind of policy making in the process of adjudication. Okay? So are we clear? So let me just summarize it a bit. So again, as a matter of broad constitutional principle, national policies and agendas of the nation are best left to the legislature and the executive because of the representative principle of constitutionalism. It is the executive and the legislature who represent the people, and they are therefore in the best position to define what the national agenda should be and what national policy should be. And in fact, if a case were raised questioning the constitutionality or validity of a law, and that specific question would actually involve questions of policy. So in other words, for example, so let's assume that there is a law, and the law says, for example, that people who don't have tertiary education are not entitled to vote. Okay, let's assume that were the case. So there's a question of suffrage, or it could be that there is a budget, there is a law and it says there that certain states will not be entitled to a certain amount of allocation, maybe for the roads. And again, that is questioned. Or it could be that the parliament passes a law saying that education is the least important. Or it could be that parliament passes a law saying that nuclear power plants will be built in Australia. Now, if there were a case that were brought before the court questioning the constitutionality of those laws, and in resolving those specific cases, the High Court could only decide that on the basis of what is best for the nation or what the national policy ought to be. The High Court will not touch it and say that those questions are actually non-justiciable. The High Court will say that they are political questions that are best left to the executive or the legislature. And so they will not adjudicate on that, and they will dismiss the case because it is non-justiciable and they involve political questions. So that's as a matter of, a broad principle. But as I said, in common law systems, such as the one in Australia, it is actually typical for judges to actually create policies, or in a sense, create agenda, national agenda, because in those areas, in those fields of human endeavor, where there is no law, there is no statute that provides guidelines, let's say, in the way business should be done, the judges will not hesitate to actually come up with a decision. And in that sense, they are actually making law and therefore making policies. Okay? So are you happy with that kind of knowledge of, the tension of when judges say it's a political question and they don't want to intervene because it's non-justiciable, and yet that other question arises that typically the judiciary does in fact impose its own policy agenda. And you will see this happening, especially in the US. You'll see this happening in the case of questions of abortion, questions of euthanasia, and so on. Judges do in fact determine. It could even be questions of gay marriage. Judges can become political activists, and to a great extent, they do define the national agenda. But, if you speak of, broad principles, the answer is no, they do not. Okay? Any other questions before we proceed? Clear enough? Okay.
Can I just say something?
Yes.
Hello, can I say
Who might that
something?
be?
Laurie,
Laurie, go ahead, Laurie.
I was just inquiring if there's any gaps in the law, or if there's any gaps in the legislation, then doesn't the common law or the judge-made law fill in the gaps? Or...
Okay. Yeah. When we say the judges fill in the gap, the judges only fill in the gap when there is an actual controversy involved. In other words, there is a proper case filed before the court. So in other words, there's an actual controversy because, it involves two parties and their rights have been affected by maybe a law, or there's an actual controversy involved. And so therefore the power of the judiciary has been invoked. That will be the only time when the courts step in to probably plug a loophole in the law or a gap in the law. But otherwise, judges are not in a position to, out of the blue, just say, there is no statutory instrument in relation to this, and therefore we say that this is what the law should be. Judges cannot do that. They will only step in to try to address a gap in the law when there is an actual controversy involved, and therefore the power of the judiciary is properly invoked in a proper case. So that involves locus standi, among others. Would that be clear enough? Any questions there? None? So we can proceed to discuss. Yes, go ahead.
This is Vivian. I was just wondering,
Yes.
with the conventions and all those unwritten sort of laws,
Yeah.
is there a specific place that they are written down, or is it just textbooks and knowledge accumulated?
It could actually be textbooks in the sense that if you look at the sources of law, so we're now looking at the sources of law. In broad form, if you talk about sources of law, you can look at the Constitution, you can look at the statutes, and then you obviously look at case law, decisions of judges. So it's not about just decisions of judges today, but decisions of judges in the past on the basis of the principle of stare decisis. In other words, as a matter of principle, judges are supposed to follow judicial precedents, meaning decisions or legal principles that have been handed down by previous judges. But another source of law, oftentimes, as you will notice when you go through decisions by judges, is that they would sometimes cite legal scholars. who are well known in the law, who are experts in the law in a specific field. And oftentimes these legal scholars would actually elucidate or elaborate or even try to propose what the legal principles should be in certain cases. And so in the field, for example, of corporation law, they would probably cite Ballantyne on corporations, or it could be somebody else. Or it could be, they'd probably be citing Justice Holmes in the United States. These people are not sources of law by themselves, but they have a persuasive effect, and they do influence the decisions of judges. So going back to that question of, how do we know where the convention is? Convention can be found in case law because they've already been previously covered by previous judicial decisions. Or there is, you might say that there are certain conventions that are just so well recognized that judges know what they are, or parliamentarians know what they are. Principles of responsible government, for example, it's long-standing, and it's maybe not in the statute books, but it's there. They recognize that. Or sometimes even these conventions can be in the form of instruments that are already enacted in Parliament in the form of I forgot the technical term there, but they actually have certain rules and procedures in relation to how to deal with certain matters. So in that case, judges also take cognizance that that can form part of what are known as constitutional conventions. So there could be various sources of what conventions are. Was that clear enough? I should be.
It is fairly clear. I just was wondering if there was actually like somewhere you could go and get all the residual powers and the conventions and all these things that influence all these discussion questions.
I see what you mean. It's like, would there be a code or one single volume of documents where all the conventions are there? In answer to that question, specifically, especially in relation to common law systems, where there are no codes, we essentially look at judicial proceedings. There is none. That's why if there were a legal question that were raised and the answer could only be given by looking at conventions, it would actually be the job of lawyers to try to determine what the convention is by doing legal research. They will have to score and search the law books to determine what the long-standing practice might be in a specific case. That's where legal research comes in. So in other words, you may end up as a lawyer doing legal research. You may end up not just looking at decisions made in the 1960s. It could even be decisions in the 1800s, and you can even go as far back as looking at decisions in the UK. Decisions maybe even in India or in other common law countries. And you use that, therefore, as a way of arguing before the court that this is the convention, this is a long-standing practice as recognized by a Westminster-style form of democracy. But certainly there is no single code, because that's the big difference between common law systems and civil law systems. In civil law systems, they typically codify their laws. In common law systems, they don't. And that is even more true in the case of political or constitutional conventions.
Okay, thank you.
Okay, so we will proceed to discussion question 3. So I'll just read it quickly, or would somebody volunteer to read question 3? Volunteers? None? Okay, let me just read it. So for question 3, Parliament passed a law that whenever a vacancy happens in the House of Representatives within 9 months prior to a general election for the House of Representatives, a member of Parliament may be appointed by the Governor General on the advice of the Prime Minister to fill that vacancy. Rule on the validity of such a law. Okay, so can I just give you 20 seconds to give you a minute, 20 seconds to think about this, And then after 20 seconds, can I ask you to kind of type your answers in the chat box? Okay, are we done there? Okay. Would anyone care to answer question 3?
Yeah, Patrick, would that be the election? Yeah, would that be the authority given to the Speaker, or in the absence of the Governor General, under Section 33 of the Constitution, a member can be elected through a by-election to the House of Representatives?
Okay. So if you were to rule on the validity of such a law, would that law be valid?
If it was agreed by the Parliament, it would be.
So you think
That's
that,
as far as I know.
okay. So you think it would be valid for Parliament to pass such a law?
If it had the majority, you could.
Yeah, assuming it was by majority.
Yes.
Yep. The problem with that answer, if we're saying that the law is valid, is that we're running that kind of answer would go against Section 24 of the Constitution, where members of the House of Representatives are meant to be elected by the people, are meant to be chosen, directly chosen by the people of the Commonwealth. So while in general, we live in a representative democracy, which means that the members of Parliament are representatives of the people, when it comes to elections or the choice of members of Parliament, it is quite clear, especially, and this is why we call it the representative principle. It is quite clear that the members of the House of Representatives, as well as the members of the Senate, can only be directly chosen by the people. So if it's the House of Representatives, they would be directly chosen by the people of the Commonwealth. If they are members of the Senate, they can only be directly chosen by people of the state. But the wording there is directly chosen by the people. And if it were therefore, the appointment is made by the Governor General, that can't be a direct choice by the people. So the answer would be, it would be an invalid law. Okay, was that the answer?
Just on that, man, Joe.
Who would this be?
It would only be an invalid.
Hold on, who would this be?
Sorry, this is Peter Ritchie again.
Peter Ritchie, yes.
Peter Ritchie.
Yes.
Just on that again, it would only become an invalid law if somebody stood up and said took it to the judiciary for review. Would that be right? Like until somebody stands up, nothing. It would be law.
Yes, that's right.
Until somebody or the Governor General.
That would be right. So unless the power of judicial review is properly invoked by a person with proper standing, meaning there is locus standi, that law would remain valid. So it will continue to be valid until such time that it has actually been declared invalid or unconstitutional by a court. Good. Okay. So we can move on. Okay, we'll go to question number 4. Can I ask somebody to read this question for us? Volunteers, just to read it.
Yeah, what is it? What is it, Manjo?
Discussion question 4. Can I just ask you to read discussion question 4? Are you able to see the screen or not?
the share screen is frozen for a lot of us.
Oh boy, yeah, okay. It's actually, now I can't do anything but, okay. So sorry, I'm just gonna have to read question. So it's a good thing you told me that. I'm gonna read discussion question 4. This was in the, this is in Moodle anyway. So the question is, a 17-year-old Australian citizen joined the Australian Defence Force, arguing that if he is old enough to die for his country, he should be old enough to vote. He sought enrollment to vote with the Australian Electoral Commission, or AEC, for the 2014 special election. The AEC declined his application to enroll to vote for the 2000 special elections on the ground that the Commonwealth Electoral Act 1918 Commonwealth required a minimum age of 18 to vote. He filed an action in the High Court questioning the constitutionality of said law. He claimed that the law violates Sections 7 and 24 of the Australian Constitution, which guarantee that members of Parliament shall be directly chosen by the people. Rule on the validity of such a law. So again, 20 seconds to think about this. And then after that, can I ask you to start typing your answers in the chat box? So rule on the validity of such law. In other words, the 17-year-old Australian citizen is questioning, you know, why he can't be permitted to vote. If he can join the army and die for his country, why shouldn't he be allowed to vote? He says it violates the right of suffrage and the guarantees which are embodied in Sections 7 and 24 of the Australian Constitution, which guarantees that members of Parliament shall be directly chosen by the people. So the question is, I mean, the task is rule on the validity of such a law. Now, before you go into this further, following, you know, an attempt to try to use the IRAC format, if you don't mind, you know, I'd like to start talking about the IRAC, and, you know, if others have to go later on, you can go. But so if you follow the IRAC format, the format usually is, you know, you begin by identifying what exactly is the legal issue. What exactly is the legal question here? Because there could be a lot of legal, you know, possible legal issues. It could be a question of civil law. It could be a question of contract. It could be a question of employment. It could be an administrative law question. It could even be a criminal law question. Okay? Now, if it were a constitutional law question, what is the question involved here? So that's one, meaning identify the issue. And then once you know the legal issue, the next question is, if this is the legal issue, what exactly are the rules that can be used or can be applied for us to be able to answer that legal question or the legal issue? So you determine what the legal issue is, and then try to identify what the legal rules or principles might be that apply or are applicable or can shed light or can help us in answering the legal question or the legal issue. And then, once you've done those two, meaning you've identified the issue, you've clearly defined what the rules or the legal principles might be, you then apply the rules or principles to the facts of the case in order for you then to be able to come up with an answer to the legal question. Having done that, you then come up with a conclusion. Okay, now, even though this seems to be the IRAC format, the best way to do this is that you actually begin by coming up with the conclusion at the start. So when you say rule on the validity of such a law, your first answer should not be the legal question involved here is whether or not, you know, that law violates the right of suffrage of the 17-year-old person. I mean, that's the legal question, right? You should begin by coming up with a conclusion at the very start. So in other words, you would probably say, I would find the law to be invalid, or the law is valid. So the conclusion is there. And then that is because this is the legal issue, and then these are the rules. This is the way I would then apply the rules to the facts of the case, and then you repeat the conclusion at the bottom. But begin with an answer already to the question. You say whether the law is valid or not, and then proceed to the IRAC format. Okay. So having done that, would there be anyone who would like to answer this specific question? Would anyone volunteer to answer that question there? Volunteers?
I can hear you, Margie.
Yes, Maggie. Yes, I can hear you. Go ahead, please,
I
Maggie.
can hear too.
Yeah, I can hear.
Maggie, did you want to try to answer the question? Or anyone else? Would there be any volunteer who would like to answer the question?
Sorry, Manjo. I think Maggie is talking, but I don't think you can hear her. She's actually
We
talking.
can all hear. We can all hear Margie, but I don't think.
I could hear Maggie. Maggie, did you want to answer? No. Anyone else?
Manjo, this is Vivian. We can actually all hear Margie, but it seems that you can't.
Is she actually? Is she actually speaking now? I can't hear anything from Maggie, although I think I heard her say something earlier. But I can't hear anything right now. Okay.
Yeah, sorry, Manjo. It's Jamie here. She just said to ask somebody else. There's something wrong with the microphone, probably.
Okay. Yes.
Hey, Manjo, Peter Ritchie here again.
Peter, go ahead, please.
Yeah, the answer that I had was it's very clear that when the Commonwealth Electoral Act of 1918 was created, that Parliament did indeed bring their minds to the age of requirement of voting in a Commonwealth election, where it has been written in very clear and direct language. So the Commonwealth Electoral Act is not in breach of the Constitution, and as such would stand in the event of a challenge on age grounds. And it's accepted and established in Australia that 18 years of age is when a person becomes eligible to vote, and any changes to this would require a change of law to be introduced by Parliament.
Okay, but that's an answer. That's good. But my question is, how about the fact that Section 7 and 24 of the Australian Constitution actually guarantees the right of the people to choose the members of Parliament? So wouldn't Parliament therefore be violating, the specific guarantees of Section 7 and 24 in legislating that only those who are 18 years old can actually vote, 18 years old and above can vote? Wouldn't that contravene the clear language of Section 7 and 24 of the Constitution?
Yeah, it's Anthony Ellum here. No, it wouldn't, because under in McKinley there was judicial support for the constitutional requirement that the members of the House of Representatives and the Senate were directly chosen by the people. That establishes adult suffrage subject to well-recognised disqualifications.
Okay, but
those disqualifications are like anyone under 18 can't vote, and there's others as well. I don't know them off my hand.
Okay.
Hi, Manjo. Can you hear me?
I could. Manjo.
Oh, hi, Manjo. It's Bronwyn. I just thought that under Section 51 of the Constitution, it refers to the powers of the Parliament to make the laws, and they then made the law of the Commonwealth Electoral Act 1918, and then that Section 93 of the Electoral Act states that a person entitled to vote must have attained the age of 18 years, and so that was a law that was made in accordance with the Constitution under Section 51.
Okay, thank you. Let me discuss that, and then I'll go back to the McKinley case. Okay, that's correct. So because Bronwyn is quite advanced, because she was now beginning to talk about the powers of Parliament. Under Section 51, Parliament actually has the power to legislate in matters affecting the good the welfare of the people. And in that case, it is within the power of the parliament to determine issues of citizenship or issues about elections and so on. So that's fine. But going back to the question of, in other words, I raised that because it has to be clear that when you speak of the federal parliament cannot actually just legislate on any field of law. Let me repeat. We will later see that the power of the federal parliament is limited to the clear provisions of Section 51 and the other provisions of that specific chapter. Okay? So, in other words, for example, there are other powers, therefore, there are other subject matters that are left only to the states. And for example, if you talk about issues of crime or perhaps issues of domestic businesses, these are left to the states exclusively, and the federal parliament does not have the power to legislate on those areas. So the power, it has to be clear that the power of the federal parliament is specifically limited to that which is provided in the Constitution, specifically Section 51. Beyond those matters, Parliament cannot legislate on that field. But if you follow Section 51, that is correct. Parliament has the power to legislate in relation to elections. But going back to that McKinley case, the question is, why would, what would be the basis of the High Court saying that it was actually valid for Parliament to legislate on this, on the qualifications of the electorate, notwithstanding the fact that Section 7 and 24 of the Australian Constitution is quite clear that members of the Parliament can only be directly chosen by the people? What would the answer be? I mean, sure, there's the McKinley case, but on what basis was the High Court able to articulate that the Constitution, that kind of qualification as to age is actually valid according to the Constitution? What would be the basis for the High Court's decision on that?
Maturity and...
Yeah, but I mean, remember, we have Section 7 and 24. So what, how can, if we say that there seems to be a right of suffrage, on what basis can Parliament...
Manjo,
yes.
Peter's trying to talk. Peter Mac is trying to talk.
Okay. Go on. Sorry, I got lost there. Hello, are you there?
Peter Mac is trying to talk.
Yeah, Peter, sorry, I couldn't hear you, but I could hear, I couldn't hear Peter. Sorry, I couldn't hear Peter.
I think a lot of people have got either slow internets or there's a bit of a delay in the transmission.
I can hear you. Would that be Peter? It's gone now. Okay, anyway, in answer to this, it's actually under Section 30 of the Constitution, where the Constitution provides that the Parliament has the power to determine what the qualifications are of the electorate. So on that basis, according to McKinley, it is within the power of the of Parliament to determine issues of qualifications of the electorate. So notwithstanding Section 7 and 24. So in other words, Section 7 and 24 does not guarantee a universal right of suffrage. Let's be clear about that. There is no such thing as a universal right of suffrage that is afforded to all citizens of Australia. Parliament can legislate under Section 30 of the Constitution what the qualifications of the electorate should be. So there is no such thing as a universal right of suffrage. It is within the power of the Parliament to determine what the qualifications of the electorate should be. But moving it a bit further, what if Parliament, for example, passes a law that says if you don't have a college degree or if you're unemployed, you cannot vote? Do you think that would be a valid law?
No.
Why not?
Because it's unfair. It's unfair to the to the majority, there's some members of the public it's discriminatory.
Okay, so you're actually right in that regard. Yes. So in the cases of Roach versus Australian Electoral Commission, the High Court was clear that although it is within the power of the federal parliament under Section 30 of the Constitution to determine what the qualifications are of the electorate, the criteria or the qualifications that they set must be reasonable, or they must be proportionate to whatever limitations that they impose. So in other words, if there is an imposition of, let's say, an intellectual requirement or a requirement of a university degree or a property requirement, those would become unreasonable and therefore will be struck down by the courts. And more specifically, assuming that the question is, that those who are in jail and those who are incarcerated, let's say for a period of 1 year, are not permitted to vote, would that be a valid limitation?
Manjot?
Yes.
When you say those would be unreasonable, how do you arrive at that being unreasonable?
That is something that the court, I'm the court, and I'm not. The court, they will only be able to provide the guidance on that in a proper case. So it depends on what it is. But the High Court has actually been quite clear that what would be unreasonable would be the imposition of property requirements or the imposition of educational requirements. The High Court has said that those would be unconstitutional limitations. If the limitation were based also on the fact of tender age, meaning age restrictions, the High Court recognizes that that is a valid limitation that can be imposed by the federal parliament. Issues of whether or not somebody is of sound mind, the High Court also recognizes that that is a reasonable restriction of the right of suffrage. But issues of limitations on the basis of education, on the basis of gender, the High Court would strike that down as unconstitutional. So
would that be unconstitutional or socially unacceptable at a particular time?
That's a good point, because if we will recall, I think prior to the 1930s, prior to 1950, women in Australia were not allowed to vote. The indigenous Australians also were not allowed to vote, and a lot of people belonging to another race, the minorities, were not allowed to vote. And this was because when the Australian Commonwealth Constitution first came about, Section 30 actually provided that the qualifications of the electorate would be according to the legislation of specific states. So whatever states, therefore, legislated in relation to qualifications of the electorate, that was the qualification as to who could vote. But now that but when the federal parliament decided to pass legislation in relation to qualifications of the Australian electorate, that therefore displaced the state legislation on the subject. And so now it is the laws passed by the federal parliament that determine qualifications. So there was a time in the history of Australia where it was acceptable for indigenous people, for women not to be able to vote, and people of other races not to be able to vote. But that is no longer permissible at this day and age. So in other words, if Parliament were to pass a law saying that people of certain minorities, even if they are Australian citizens, cannot vote, that will likely not be permissible. So let's say there would be a law passed saying that if you join, if you become, going back to the legal memorandum problem, if you had at one time joined the army of another state, you'd probably not get residency anyway. But what I'm saying is there might be questions on what Parliament can pass. Okay, clear on that. So going back to the question that I have, in the case of Roach versus Australian Electoral Commission, the High Court ruled that if the federal parliament were to when the federal parliament passed a law saying that people who were imprisoned for a period of 1 year did not have the right to vote or were disqualified from voting, the High Court actually struck down that law as being unconstitutional because it was unreasonable. But in relation to the 1998 law pertaining to qualifications, and in that specific amendment, the federal parliament said that somebody serving a prison term of 3 years who was disqualified from voting, the High Court actually upheld the validity of that specific law. So that goes back to the question of what is reasonable and what is not. If it was 1 year, it was unreasonable, therefore unconstitutional. If it was 3 years, it was reasonable, therefore constitutional. So to a great extent, therefore, that's when you will see that, you know, the courts actually do get into the phase of determining policies and agendas of the nation, because it was the High Court who determined the cutoff point of, you know, what was a valid law or not. They said no if a convict was disqualified from voting if he had been in prison for 1 year, but they said that it was a valid piece of legislation if the disqualification related to people who were imprisoned for 3 years or more. So that obviously was a policymaking decision on the part of the courts, but that doesn't usually happen. But that shows us that the High Court can set agenda of the nation. Okay, so it's 7:15. We're done with all the discussion questions I had, and actually I would have wanted to do the IRAC, but I don't know. It's 7:15. Do you want to continue or we end this right now? Because some of you may have classes after this. We still have 31. Oh, that's good. No one has dropped out, which is good. I'm happy about that. What's the pleasure? I mean, I could continue for the next just to go through the IRAC format, but then after that I have to end because my 4-year-old daughter is beginning to cry. I don't know even if you can hear from the background. Do you mind if we extend this by another 10 minutes and then we end it? We call it a day after that?
Can you hear me, Manjo?
I could hear you. Who might this be?
Yeah, it's Andrew here. There's actually only 15 of us left.
Oh,
most people have
yeah, that's what I meant. It's frozen. It's frozen. So I actually see 31 here. Okay, so I think we could call it a day. We went through the IRAC format a bit anyway. So I guess that's it. Will there be any questions before we end tonight's session? None?
No, thanks, Banjo.
Okay, thank you, everyone.
Yeah, all good. Thanks, Manjo.
I'll see you soon. Good night, everyone. Thanks for joining. Bye.
Thanks, Major.